this officer, Mrs. Chaya Sharma. As you all know, in the criminal justice system, in large number of cases, the seeds of acquittal lies in investigation. So we would love to hear, madam, in 5 minutes, and then we will open the floor for an interaction.
So if the House permits, I'll forward my comments. Everything has been said, and we'll take the questions from
Lovely. Fine, that's fine. Thank you so much, ma'am. You have been so generous that we saved these 5 minutes and we go ahead. So we have roughly, now we have 20 minutes. So before we break for lunch, and we reassemble here at 2:50. So we have solid 20 minutes. Please raise your hand. Please give your name and are you from the police, prosecutor, or you are a civil servant, or you are an intruder into this hall. So please identify yourself. Judiciary, yeah, of course. Our very learned, these are our probationers from the Delhi Judicial Academy. So thanks a lot to your director. Thank you very much. So please raise your hand, identify yourself, and I'll start moving, showing my finger. Who should ask? Go ahead. And other panelists who are here, they can also raise issues. It's not that only the probationers. Yes, be loud, please. Yeah. Give the rolling mic. DJ Saatko.
Myself, Mark Sunday. I'm an additional prosecutor. Hello. Hello. Myself, Kumar Sanjay. I'm additional public prosecutor in Delhi. Sir, I used to remind myself whenever I go through the text of the criminal law that certainty of or deterrence of law lies in the certainty of punishment. If there is no punishment, there is no law or no meaning of the machinery. Because once a accused is being left scot-free, he goes in the society and he just tried to convince some other people also that you do your misdoings, there would be nothing. Only there is a case of bail and jail at the initial stage. And what happens after bail and jail, no one knows to the case. So our thrust may be whatever the machinery we have, because it's a relay race, it's not a solo race. And here in relay race, if I count 4 persons, the first one is complainant, the second one is police, the third one is prosecution, and the fourth one is judiciary. If any one of these four runners would default in this race, the whole system or the purpose would be collapsed. So far as my concern is, my department concern is there. I have occasion of reading the infrastructure structure of many of the states, and in fact I am also doing research PhD in the prosecution reforms. I get to know that in none of the states prosecution is in a position to make itself compatible with the police and judiciary. Because it's a very good thing that police is becoming mightier and judges are becoming more robust. But the link which connects police and judiciary, prosecution is gradually becoming weak. So that is very matter of concern.
Your comments are very stimulating. Very good. I appreciate that. If you have any question, do you have any questions?
Question is, because we have all the things before us.
He's already doing his PhD on prosecution. That's amazing. Please be seated.
Thank you, sir.
Thank you for your comment. Okay, very good comment, and we welcome it. On the left hand side or in the center? Yes. Please identify yourself. Please take the rolling mic. Let me acknowledge the presence of Mr. Mahapatra. He has been our Joint Secretary to the Government of India. Then we have Mr. Ghosh, Secretary in the Election Commission of India. A number of civil servants are here. I'm sorry I'm not able to see and then identify them. But certainly I'll meet them during lunchtime. Thank you. Please go ahead.
My question is
Name, please name.
My name is Mukesh Dhada, I'm an Irish professional.
Yes.
My question is, ma'am, that earlier Supreme Court was on the verge of widely worded. And the same question goes to Chayam also, because the police will be the one who will be charged, who will charge the people. So, do you think that it will have, that Supreme Court is trying to limit its scope to that case of Kedarnath case, and now it has been more widely worded, so will it impact the rights of the accused and people?
Thank you. So, should we first start with the police? What's their perspective? Or, madam, no, because I want to complete the cycle. The police, the investigator, the prosecutor. Okay, madam, please go ahead.
Well, so 1964 judgment you already mentioned Kedarnath, that is the Constitution Bench judgment. That had already narrowed down the concept of sedition to eliminate the aspect of any peaceful actions. It was limited only to armed actions. So, if you see the definition, now when Supreme Court considers it, they will consider constitutional challenge not just to the previous definition, but also to current. The previous definition is also still relevant because all the actions that have happened prior to 1st July 2024 will be governed by that law. So both will be examined. But I don't know if I'll have to deal with this matter but I can give you my personal view. I can give you view of the opinion, because view of the Union of India, because I have not been briefed on it. But my personal view is, please see the definition carefully. It has been broad-based in its ways. That if you do this by financial means, if you do these by, so these are, the expansion is on the ways in which you can do it, but they have kept that narrow interpretation of doing an armed rebellion. So if you open the definition, the new definition. So if you see the new definition, 152. Whoever purposely or knowingly, this has been introduced. I'll mark also what all were introduced. So 152, if you see, purposely or knowingly is introduced. Now what ways, either word so and so, this was existing in the previous definition. By electronic communication, this is new. Or by financial means, this is new. Or otherwise, excite so and so. Now this is also new. Secession or armed rebellion or subversive activities or encourages feelings of separatist activities or endangers sovereignty or unity or integrity of India. So they have already, in my opinion, they have already excluded the aspects that were excluded in the Kedarnath judgment of Constitution Bench and the interim order that was passed by the Supreme Court when hearing the sedition. What was sedition being used for? And the explanation also makes it very clear that comments which are disapproving of the measures or administrative actions of the government with a view to obtain their alteration by lawful means does not constitute an offence under this section. Supreme Court will consider, Constitution Bench will consider the previous and the new definition both, and if they feel that new fetters need to be introduced or some new guardrails need to be introduced, they'll introduce it.
Thank you, ma'am. Anyone would like to respond? Madam Chaya, ma'am?
I think ma'am has covered the question adequately. As far as use of sedition, for people who were earlier, using it for that part, where there were related comments which were considered anti-national. So that part that has been taken care of in the they have changed the definition to that extent and have clarified what is the new definition. So as the new law unfolds, as we start practicing the new law, we will be handling it. As of now, I think, like Matt said, we have the older cases still being under sedition or doing that. They will continue. However, the new from 1st July, whatever new will happen, we will be following the BNS.
You have some. Naveen.
Different opinion on this. I think some of these terms would need to be defined. I am still unsure of what the feeling of separatist activity would mean or what subversive activities would mean, very subjective terms, and without any clarification on them, it is difficult to prevent a prosecution from happening. And while the conclusion of the trial, decisions on guilt and all of that can be done, but that is very rarely the objective of trials in such cases. It is the process, which is precisely what the punishment is. And I think a clearer definition on this would be very helpful.
Thank you. that out to the audience.
Sir, I also have a question.
Yeah, please go ahead.
My question is to the panelists who represent the citizens from outside the government. The question is that the bottom line or one of the key aspects of these new laws is to prescribe timelines to bring forth speedy trials. And we are also introducing several technologies, for example, interoperable criminal justice system and digitizing a lot of processes to make it speedy. But I still believe there are huge amount of challenges in bringing speedy trial to actually happen. So from you, what do you want to tell us, administration, police, prosecution and judiciary, what we can do to actually bring this dream into a reality?
Thank you. Any panelists would like to respond? Sir.
Yeah. It seems we are the only people who are representing citizens. But then, ma'am in the question has forgotten what I said. The whole objective of decolonization is that all of you are representing citizens. So all of us are representing citizens. I think, and Ansariji represents citizens.
And just in the last session of the Part-3, I stated that the institutional change and capacity building are hard mark of the implementation of these laws. So we have to do the capacity and then institutional change. Fast track everything, there will be a position to fast track the trial. But there is a timeline. Earlier also there will be a timeline for their trial. But we will not be able to adhere that timeline. So timeline will not to resolve our case. Unless there is an infrastructure is built up, the institutional change has not been brought out, and some capacity building has not been taken, so we will not be in a position to fast track the trial.
I think more of this will be answered in your post-lunch session when we discuss the BNSS. But just to take from what Ansari sir said, ultimately, see, if you are not going to spend money and have more judges, if you are not going to have more police people, our police forces are and more prosecutors and independent prosecutors. I mean, take something. I mean, of course, it's not BNS exactly, it's Bhanasur, but take something as simple as now we have said that you have to first hear the accused before you issue, before you move forward in that. You have to hear the complainant before you move forward in that. Now, that is a good intention that it has to be a participatory criminal justice process. But at the end of the day, you know what's going to happen. It's going to have more delays. Even for issuing summons first, you have to hear that person, and more lawyer will come and say, advise me, plead guilty. Abroad, everyone actually pleads guilty because, as one of the prosecutors said, what is required is certainty of conviction or certainty of result, not even conviction, certainty of result. If you know that you are accused of a crime, within 3 months the prosecution will end in acquittal or in conviction. There is this desire A, not to commit the crime, B, to plea bargain and accept guilt. But in our case, we know the process is the punishment and the process is enjoyment for people also. For some people, the process is the punishment, and for some people, the process is enjoyment. You are sitting at home and the case is going on bail, and the case is going on for years and years. But yes, that is, I think in the post-lunch session, you will
Sure. Yes, please go ahead. Our judges. Yeah, please.
Good afternoon, everyone. So my name is Priyanka, I'm BNS officer. Sir, continuing with the question on sedition, as Chairman said, the old cases will continue under the old law. But as per my knowledge, the Supreme Court put all the old cases under sedition in abeyance till the government reconsiders it. Now the government has reconsidered and deleted the provision as per the new law, BNS. So, I would like to know your opinion as to how those cases would be dealt, or what would be the Supreme Court's opinion on that, further action on that.
Definitely, if the Supreme Court has put the case on the bench, like what I meant to say was that if a particular, not just issue, but if something has been sorry. So what I meant to say was that if whatever section has been deleted now, say not only this sedition, but maybe any other thing. For example, for 377, for example, that now it has been deleted, but earlier it was there. So even in that case, I was just trying to make a point that if it is there and if it is in a previously occurring event, then the old IPC will continue. However, once from 1st July, we are only going to be doing it from the new perspective. Now this issue about how a sedition is being defined, what will happen with the previous cases, as such, even in the previous cases, I am sure no hurried judgment was coming or no hurried action was being taken. So if the cases have been put in the place, then they will remain there. All I am trying to say is that they will stand until unless a final decision is taken on it. But however, from 1st July, the way we were handling sedition earlier will change. So, and like Lalit said that maybe a little more more definitions may have need to be introduced. It is also sometimes the kind of acts which sedition, the people who are doing an anti-national act do, or maybe people who are in insurgency areas do, you may not be able to put it in a box and say, okay, this is anti-national, this is not anti-national, or you may need to have a broad-based kind of a thing, and then interpretation of the law can occur subsequently. Like Sir said that a law needs to evolve. So yes, as a matter of evolution, this will also change. So when the judiciary interprets a particular law, accordingly the ways the police are going to use it, the police are going to perceive it will change. For example, there are a lot of things which have been brought in the present BNS, which were earlier part of judicial enactments. It was never part of IPC. So those things that have been brought in are all those things, like for example, zero FIR was not there earlier. But it was in practice because some decisions were there that yes, zero FIR can be registered and in what manner, or some administrative instructions were there. So it's not as if zero FIR technically was not there. EFIR, Delhi Police has been doing since 2018, and we have a lot of data. So what I'm trying to say is that the time passes, we are also experiencing a new change. So we are handling our challenges accordingly. So as far as
As far as your question is concerned about the pending cases under 124, which have been stayed by the Supreme Court, the deletion is, the law does not say that the deletion is shall be treated from that date. And as we all know, substantive offences act prospectively. So those cases stand there. But since they have been stayed by the Honorable Supreme Court, so till the time they take a final decision, so their fate will be decided according to the decision of the Supreme Court. Of course, 531 says na. 531 says BNS.
you can't let's say कि हम इसको new way में interpret करें.
Major sections are covered. Because earlier it was Raj
Deshro.
Now it is Deshro. So our discussion will be considered the definition after the matters. You got to the sovereignty, integrity. The definition has to be more detailed for the purpose of prosecution of the case.
But as Madam said, it will evolve over a period of time and it will make cases will come up with some constitutional. We get the jurisprudence. But of course, the existing jurisprudence will continue to hold on. That is the main important aspect. And the most difficult part will be the number of pending cases. The IKTC one shows the number of cases. These cases are going to be there in the course of another 20 years, minimum 2 decades. So we have to keep IPC. In one case IPC, another case BNS, and I am really sorry for the law students now. अब वो BCI को एक और कोर्स इंट्रोड्यूस करना पड़ेगा, IPC भी उन्हें पढ़ना पड़ेगा और BNS भी पढ़ना पड़ेगा, क्योंकि अगले 20 साल तक जब तक वो वकील जज बनेंगे, तब तक उन्हें दोनों में केस करने पड़ेंगे.
That's great. These are some of the challenges which have been flagged. Is there any other question? Or can I ask a question on behalf of our citizen? So, Mr. Ghosh, sorry. Yeah, please go ahead. आप पूछिए, पहले आप पूछिए.
I want to put a query as raised by Mr. Nabi regarding if a person is arrested in a case of organized crime. The definition of both in the BNS and as well as in the Moko crime the same. Only the difference is punishment and the bail. So it is purely on the discussion of the investigation agency as to in which provision he sent him to for trial. Who will decide? How will it decide? And the same in respect of the UAPA. The same provisions are incorporated in the
There is a special mention with regard to EUPA, terrorist act. You have been hired under one Then you mentioned that whether the EUPA will be applied or this BNS will be applied. So that will decide whether the criminal police not to the right of the police. But there is no such amendment, no such mention for the applied side.
That's why I said maybe it's essentially repealing or in the state legislation.
So there is a vacuum inside that is there is a vacuum with that effect.
Actually, organized crime.
It is a gray area. We have raised this definitely still there.
And there is,
But the way of handling is totally different. There are a lot of safeguards available. There are no handling safeguards available in the BNS.
If someone also does, again coming back to nitpicking, if someone sees the legislative arrangement of that section, terrorism, it comes in the bodily offences. But yet, there can be a terrorist activity like blowing up a bridge which involves no bodily offence at all. So, there's no thinking through, I would say.
just on organized and terrorist, these are some issues because from subsequently also the conditions of bail that are applicable, the manner in which the trial will take place, what are the safeguards for the accused against the accused, because world is also seeing, nations are seeing, world is seeing terrorism in different forms. And I think one thing that, I want to just add when ma'am said only the citizen representatives should answer this. In a system of democracy, where it is an elected government, when we are all elected government's representatives in some way, then we represent the citizen who is not before the system, but a citizen who will be impacted by whatever is happening in the world. So I think our role as representatives of those bodies to represent those citizens who are not, because court will only see who's before the court. The court will not see who's not before the court. That is the job of the public prosecutor, the government lawyers, or the government agencies. So please keep that in mind. Please stand for that citizen who's not in the room.
Yes, ma'am. I have an issue. You see, we have litigation explosion. It's crossed more than 3 crores. And this is when we are not leading a constitutional way of life. Just imagine, if 140 crore people know about their rights, what is the impact? And for me, in the criminal justice system, the most important person is not IPS or DG or police commissioner. It's the constable on the ground. He is a Supreme Court judge for me. If he does justice, the things will not come to us. So what I'm saying is that today when we had a kind of we had an introductory, we had an inaugural session, it seems that corruption is not an issue at all. Of course, we are discussing these 3 subjects. Corruption is certainly an issue. It certainly impacts my right. Look, go to a lawyer, I become a primary, I become a victim. When I go to him, I become a secondary victim. Mr. Ghosh, I'm sure you know how things are. I'm not asking you. You are.
Shall I
So
answer?
what I'm saying, just for a second, hang on. So the ethical framework under which the criminal justice system operates is very, very important. The role of a police officer, right up to the level of constable, the role of a prosecutor, and including the role of the judges, with the deepest respect to our very honorable and a very well-known and upright judge. So I think the issues of corruption, behavioral issues are as important as any other issue. And what will be the impact of the judgments of the Supreme Court, which are they going to apply now to these new acts? You answer. The principles are written on the judgment of the Supreme Court. I'm sorry.
No, so the Supreme Court judgment has 3 aspects. One is the facts of the case,